Session is closed.
What's your plan?
Much obliged.
Please, Lordship. Lordship, I beg to mention item number 5.
Fine.
Lordship, I pray that I may be granted 3 weeks time to file counter affidavit filed by the state.
You would like to file affidavit in reply.
Lordship,
MS so-and-so learned counsel for the petitioner submits that she may be granted some time to file affidavit in reply to the counter affidavit filed by the state respondent. Prayers allowed, list after 3 weeks.
bless your Lordship.
May I please, Lordship, I beg to mention item number 7, my lord. Here I am for the respondent, so respondent, my lord.
Mr. So-and-so learned
yes.
counsel for the respondent number 7,
Yeah, for the sole respondent,
sole respondent, fresh for and granted
2 weeks time, my lord.
2 weeks time to file counter affidavit.
Lordship, interim order
Again, Mr.
TB Jammu.
TB Jamil learned counsel for the petitioner present. Next, for an interim order passed earlier, shall continue.
Yes, sir.
Please, Lordship, I recommend item number 6. I may be allowed 2 weeks time.
On behalf of
Appearing on behalf of my senior certain book.
For petitioner,
Yes.
what do you want?
2 weeks time
For
to acquire instruction from the client.
Mr. So-and-so learned counsel appearing on behalf of Mr. Tongpo Pongana, learned counsel for the petitioner. Press for 2 weeks time to obtain instruction. What instruction you want?
To acquire instruction.
My lord, actually, please read petition was filed after the filing of a writ
Yes,
petition
yes, yes.
challenging the rule.
Withdraw it. What instruction?
So
It has not been allowed.
We want to take the instruction from the client.
Why? There's nothing.
Or else
Nothing survives.
Nothing survives in this writ petition.
Do you have filed this petition that you have challenged the rules
Yes,
and that writ petition has been disposed of? It has been dismissed.
my lord, a chance will be
So
given.
there's no, I mean,
Since the
surviving cause.
instruction, a chance will be given.
okay. What is that? So and so for a Tongpo Pongana. Press for 2 weeks time. To after this, Mr. Takakichu, learned counsel for the respondent present. Press route, this after 2 weeks.
Much obliged.
My lord, I also like to mention item number 2 in three, my lord.
2 and
My
3.
lord, here, I'm led by my senior Ajo. My lord, he has some difficulties today. So I have consented with the parties to take up the matter on 5th of October. So my lord, may kindly list the matter on 5th of October.
On the consent of the others, learned counsel for the respondent
My lord,
and respondent, Mr. Takakichi, learned counsel for the petitioner. Press for and granted 2 weeks time.
my lord. If this can be on 5th of October.
List this matter on 5/10/2023. Impleading song, learned additional present.
And so for the petitioner.
And so for petitioner in writ petition 192,
My lord, yes.
Your Lordship, yes.
2016. Present.
Not-
Please, Your Lordship,
Yes,
I beg to mention item number 11 and 12. Here, the pleadings are completed, so it may be kindly listed for admission here.
it's listed for admission hearing only today.
We have
We'll
filed,
see, you'll be there.
we filed a reply just this morning.
Okay. Record shows that you have not filed the affidavit.
Yes, we have filed this morning.
11/12.
Yes,
So when do we want?
After 2 weeks, Lordship.
MS so learned counsel for the petitioner submits praise for and granted 2 weeks time. List this matter for admission hearing after 2 weeks.
Bless your Lordship.
that's
May I please, Lordship.
Yes,
Lordship, I beg to mention item number 9, Your Lordship, on
Nine.
behalf of the counsel for the petitioner, Mr. P. Your Lordship. Lordship, we are yet to file our affidavit in reply. File to the affidavit in opposition filed by the respondent number 3. So operated this matter may come up on November 30.
Mr. So-and-so, learned counsel for the petitioner, press for and granted. 2 weeks time.
Lordship, November 13, Your Lordship, the fixed date.
Your Lordship, if the matter can be fixed on 13, Your Lordship, it will be convenient from the
13,
leading counsel, Your Lordship,
13/11,
13/11, Your Lordship. Since the council is from us.
granted. 2 weeks time.
Lordship, there is an interim, Lordship.
Mr. So-and-so, learned counsel. Learned PP and Mr. So-and-so, learned counsel will be present. List this matter on 13,
Yes, Lordship.
1/3/10/2023.
Lordship, there's an interim, Lordship.
Interim order was earlier shall continue.
Like, Madam.
May I please, my lord. My lord, I beg to mention item number 10.
Yes,
Lordship, I'm submitting on behalf of
Mr. K. Angami, Learned State Council. Press for listing the matter after 3 weeks,
Lordship.
so as to file him, so as to enable him to file affidavit in the opposition. MS so-and-so, learned counsel for the present. List after 3 weeks.
License.
May I please, Your Lordship.
Yes,
I beg to mention item, hearing item 23, Your Lordship. Your Lordship, if the matter may be listed on 3rd October.
why so?
Your
3rd
Lordship,
October is an auspicious day for you.
Your
What is
Lordship,
this matter?
Since I'm not in this case, the
So-
legal counsel,
so-
he has some
So
difficulties.
why you are mentioning? Take the file and get ready. We'll see it. If you have any difficulty, we'll see.
Your Lordship, the leading counsel has some difficulty today.
See, learned members of the bar. Why, if it is to be mentioned, all the matters, why it should be listed? It's the wastage of everyone's time.
Your Lordship, if the matter be listed on 3rd.
What is the matter? Do you have the brief?
Your Lordship, it's regarding.
Get the second copy of the,
Family
from the
pension.
court and you go through the petition. We'll see after some time. All right.
Your Lordship, I have similar prayer. item 14.
Similar prayer is rejected. Which item?
Item 14, Your Lordship.
14.
I have the consent from the other party as well, Your Lordship.
MS so-and-so, learned counsel for the petitioner.
Yes, Your Lordship.
Praise for and granted 2 weeks time. List this matter after 2 weeks.
Your Lordship,
14,
the matter may be listed on 6th.
6th, then. 23, I'm not granting. 14. You take the second file,
Much better.
second copy.
Motion. Item number 1.
Yeah, please, Your Lordship.
Yes,
Lordship, this IA is for implement of
this
the
is amendment or implement?
amend,
When
implement and then amend.
when we, if you are allowed to be implemented, then only you may make an amendment of this. All right,
Yes, Lordship.
or Mr. So-and-so. Sir, any objection? Anybody? Appearing for the state, I mean, Alice contemptor. Nobody.
In contempt, Your Lordship, connected contempt, I am appealing for respondent number 2.
Where is the connected contempt?
With this.
Okay, contempt 2.
No,
You are appearing for?
for respondent number 2.
Respondent, who is for 1?
Lordship, I am agreeing for respondent number 1.
Why you are not complying?
Lordship,
Comply the court's order.
No, Your Lordship, it has been complied.
Then
It has
we'll
been-
close it if it's compliant.
But then the case of the petitioner is that it is not in terms with the direction passed by this court.
Okay.
So that is why they want to.
So it needs to be. Needs to be heard.
Yes, Lordship.
Okay. Then we'll allow the implement.
Lordship.
Heard Mr. So-and-so land council for the applicant, petitioner. And also heard Mr. and Angami for
Respondent number one.
respondent number, Alice contender number 1. Mr. T.B. Jamid land council for respondent number 2, Alice contender number 2. By filing this application, the applicant press for implement of the new incumbents. Namely, who are they?
Paragraph number 3 at page 6.
Yes, page 6, huh? As respondent number 7, 8, 9, and 10. You just write all this name, huh? Page 6, huh? Paragraph 3, page 6, name of the incumbent. Expert. Having considered the prayer and coupled with the fact that the respondents have no objection. This could deem it appropriate to allow the application by impleading the Shri so and so, then so Shri so and so, so and so. 4 respondents. As respondent number 7, 8, 9, and 10. Mr. Accordingly, the above mentioned officers, namely so and so, be implemented as respondent number 7, 8, 9, and 10. Next, the petitioners shall take the steps for amendment of the cost item accordingly. Mr. The IA stands
Your Lordship,
disposed of.
the main petition is fixed tomorrow. However, in the cost list that has been made, it's not there.
We'll see tomorrow.
If an supplementary list can be.
We'll see tomorrow. You make amendment of the cost title and then we'll issue notice.
In that case, your lordship, let the main case also be listed along with that.
No, after the amendment, so make the required amendment. Amendment. Issue notice to the respondent number 7, 8, 9, and 10. Then in main case, in view of the order passed so and so, list this matter after 3 weeks. Issue notice returnable with 3 weeks. And then the learned consequence for the petitioners shall take steps for service of notice so and so, so and so. Within 2 days.
And your lordship, I may be allowed to file an additional affidavit to the reply.
It's okay.
To the reply, your lordship. To the additional affidavit to the reply filed with the.
Sir, how we can go and go? And again, he will file an affidavit in reply to your reply.
Your lordship, what is?
You bring it here, additional affidavit, it's okay.
Your lordship, considering the fact that this is a contempt petition, your lordship.
Okay.
In the additional.
In May, huh?
In the
In the
main.
May, Mr. T.B. Jamil, learned counsel for the LS contender number 2 is permitted to file appropriate additional affidavit.
Oblige. I love oblige. Oblige.
Different orders.
Question. I know.
May I please, your lordship?
Yes,
The lordship, 5 weeks may be granted to lordship for filing affidavit, your lordship, on the on the amended petition, your lordship. I am yet to serve the amended petition to the newly implemented.
you sir,
Yes, Lord. I'll do that, lordship.
Mr. Moajawid, learned counsel for the petitioner. And also Ms. Libika, learned state counsel. Mr. Mohammed Learned Counsel of Petitioners is permitted to serve the amended copy of the writ petition.
Yes,
So that Learned Counsel for the Learned State Council list of MS so Libica Learned State Council is also permitted to is granted 3 weeks time,
4 weeks, Your Lordship.
4 weeks time to file a counter affidavit. List after 4 weeks.
Lodge.
Your Lordship.
Item number 8.
Sir, what is this?
Lordship, in compliance of the court's order, all the parties had a joint sitting
Yes,
at Gauhati on 15 and 16 of September.
yes.
Your Honor, but because of certain issues, the matter could not come to a settlement. Therefore, the parties, the respondents, we all have agreed to have another joint sitting. And for which I request this court if the matter could kindly be taken up on 18 of October. And before then, the joint sitting will be held as per the convenience.
Ready? Mr. Limatos Learned Counsel. I Limatos Learned Counsel for the petition and also Mr.
I'm sorry, Your Lordship, on behalf of YP Kutta, Your Lordship.
Mr. So and so for respondent number
2, Your Lordship.
2.
State Lordship.
State. Your then first write his name, busy moment. Okay, Angami. For respondent number 1 and Mr. So and so for respondent number 2, 3, and 4. The Learned Counsel for the parties jointly submitted that the endeavor to settle the dispute amongst them could not be materialized as of today, as permitted by this court on 16/3/2023. Therefore, press for another 6 weeks time.
18th, matter may be fixed on 18th of October.
Then 4 weeks, 3 weeks. 4 weeks, 18. Press for another 4 weeks time to resolve the matter amicably. Mr. Praise allowed. This matter on 18/10/2023, so as to enable the parties to make an endeavor to resolve the dispute amongst them.
Item number 15 to 17.
What to do, sir?
There are 2 cases, my lord, in this. First case is 3 of 2023. That, my lord, challenging the 2 parts. One is the civil adjudication under section 8 and one the again the ECI for question of the ECI. So that is why 226, Red Brick 482, we have filed. And there is an interim order, yes, interim order which has been passed by this honorable court. So far as 8.1 is concerned.
Yes.
And ECI, there is also an interim order which was passed by the court that no coercive measure should be taken, but they can go ahead with further investigation. That was again clarified by this order that they were pending. This pending will not be a bar for further investigation of the matter. That's the position as it is, my lord.
What is IA for?
I is for vacation of the interim.
Vacation of that ECI, and that vacation has already been taken consideration by the court.
You have filed the affidavit.
Lordship, I have filed the I.
No, have you filed the affidavit?
In both the cases, I have filed.
Affidavit in opposition. So I'll fix it for hearing.
No, I will have to file only affidavit reply. So far as the 3 is concerned, and also 6, but today is so far as 6 is concerned. 6, that's the second case. The 6, that's why your lordship has called for a case diary. Whether in a predicate offense, my name has been reflected. What stays in the case diary? Because it is a state and within the court. But there is a relevance between both the case. Lordship is right, there is a relevance of both the case. Because suppose tomorrow, I am not found in the predicate offense, whether I can be dragged by the ECI in their case. That's the whole. Either directly or indirectly. My learned friend has relied on certain judgment in that second case. But that judgment, my lord, I think my learned friend has not gone through it. That it was put to challenge before the Supreme Court by similar nature of case, and it has been stated by the Supreme Court. Directly or indirectly also, if you cannot drag it. Directly, if it is involved, that's a different thing. Directly. But indirectly also you cannot. So that's why whole, my lord, there is latest judgment of the Supreme Court, which the matter was taken up by the apex court, my lord. Kindly see Supreme Court how it is being dealt. Entire prosecution, my lord.
Just wait, just wait.
That's why it is stayed. And that's my learned friend in
Yes.
Impleading offense relied certain paragraphs.
Sir, just wait.
Yes.
He has filed an IA for vacating the interim order.
Yes.
So what is the difficulty in, is there any
The
difficulty? in-
difficulty, Lordship, is suppose the court has given me the liberty to proceed with the investigation.
Yes,
Now, here is a case where the opposite party, the respondent on the IA, he is sitting in Dubai.
Mhm.
I issue him summons. He does not come. How do I proceed with my investigation?
Okay.
Court says no coercive steps, but he has to at least respond to the summons. Now, where do I go?
No, if
Sir?
they are big machinery. They should not ask the court, like in I remember, Article 370 was argued before Supreme Court. Court said and the council said, we are not here to give an advice to the other side, how they will deal with the evaluation. How it will go.
If my
So that's
senior,
That's why modification.
But
might not be
that-
modified.
if my senior is suggesting
You are,
we do an operation like Israel, we are ready to do.
Not exact, don't, you know, you are a big, my lord, ED,
No.
enforcement directorate.
If I have to go by the process of law, I have issued him summons, at least he has to comply. He has to cooperate with the investigation, lordship. Sitting in Dubai, court says no coercive step, or okay, no coercive step, but let him.
let
him
the
comply with the
petitioner
process.
cooperate with the investigation.
No, there is absolutely, what was the order that was clarified by this court? That
Court says you go ahead with investigation.
Yes, there's got more, man. They know how to do it. How to do it, my lord, your lordships will not say, go and pick up this matter.
But then at least, no, at least this court can say that the petitioner should cooperate.
Yes, only that much I agree with
You cooperate
Email, they have sent.
and we'll fix the matter for final disposal.
Yes, I have no difficulty.
Let us do one thing. We'll admit this petition, fix it for hearing. Any that you may choose.
But
But then
only,
in the meantime, you have to cooperate.
Yes,
my lord,
that is.
no, what is there? My lord, the only difficulty is what about 6? That 6, my lord, they will not go ahead and file any complaint. That's they have to make an assurance before the court.
No,
Let
then,
them not file, because I am arguing on that.
Sir,
Because what will happen, they will certify, one
Sir.
second, what they will do is, my lord, in the particular complaint, suppose tomorrow a complaint, like a charge sheet is filed, what remains for adjudication of this matter? That is why I am praying for an interim order, insofar as 6 is concerned, my lord.
Lordship, I,
Look,
with respect to my senior.
I have come for questioning, my lord, I have come for questioning of the ECI. What jurisdiction they have got? There is a question with great respect, I am telling your lordship, there is a question of cooperation where you don't have a jurisdiction also.
sir, that will consider.
No, that's
That
what I'm saying.
We'll definitely reserve that.
This is a subject in an enforcement director. A law has been made, your lordship know, it's a very draconian law which has been made. And what the apex court has also said, it is Vijay Madan Lal, number of cases. All the procedure has to be followed. All the procedure.
Sir, what to do? Law is law.
No, that's what I'm saying. I'm not saying, I'm saying where is your authority to investigate this person? That's what I am on with.
No, just let us do one thing. Let us do one thing. We'll fix this matter for final disposal. You choose a date. In the meantime, you will file a reply. The interim order passed earlier shall continue. In the meantime, you have to cooperate with them.
We are, I mean, even under.
If you are, it's okay. If
We are cooperating with it.
if you are,
What has happened, immediately said.
sir, if you are cooperating Even if we pass, there's nothing how.
Yes, we are cooperating.
But he has made a statement. Why it has to be vacated? Because he's not.
Only one prayer I am making.
Interim order will remain, but you have to cooperate.
Let three, my lord, your lordship is so far as three is concerned.
Hmm.
But this is three, my lord, of three. But so far as six is concerned, there is an interim prayer which has been made. Six is concerned. Six is a different, my lord.
Hmm.
That is not a ED. This is the state of Nagaland, my lord. No, my lord, CD was called for. If so far as six is concerned. my lord.
Six, you are not concerned.
No, six, I am concerned.
Okay.
Because he is asking for the quashing of the FIR.
Hmm.
So far as we are concerned, we draw our source from the FIR and then we investigate.
Hmm.
So if the FIR goes, I am out. He would like to make a submission in that.
No, this interim order was earlier shall continue. Well, clarified, and then in the meantime, the petitioner will be directed to cooperate with the
My
investigation.
lord will kindly see the last order by
Yes.
this apex court.
Yes, I've seen.
No, see the apex court's order, recent. That's why they are relying and they have kindly see, they have not gone to that order also. Kindly see the latest order, my lord Supreme Court. There cannot be any prosecution. In the given, at least there cannot be any prosecution against present petitioner under 3 and 4 of the PMLA Act. Now kindly see next, my lord.
No, in the given
No,
circumstances.
that's why I'll show, my lord. Same, I have got what I have done, my lord. I have made everything for your lordship. Kindly see. Further proceeding, including prosecution, while the present cell remains state until further orders. What, my lord, step the apex court has taken, kindly see. And I have, my lord, my learned friend has quoted certain paragraph. I have gone through entire paragraph. The judgment, kindly see. Half paragraphs, my learned, the ED has in the affidavit. One of the paragraph they have stated and said, court has passed that order.
Against this order, all this
Yes,
order
my
has
lord,
been
kindly
passed by
see.
the Honorable Supreme
My lord, what my learned friend has quoted in the affidavit. Quoted in the affidavit in 6. I am talking about 6. I am not talking about 3, my lord. 6 I am talking about. So I will read it.
This one here.
I'll tell what is about this, my lord, and how my learned friend has referred. We are talking about 6, my lord. Kindly see 6 for a moment, my lord. For a moment, kindly see 6. My lord, kindly see. I'll just show, my lord. That's this one, 6 of 2023 affidavit by the ED. What you found?
Of 11 September. File on 11 September.
We have received on 8 years.
Yes.
Now, my
Which
lord,
page?
see
Which
para
page?
23, page 23. Page 23. Page 23.
Yes.
Kindly see 4.6.8. What you got it?
Hmm.
The division bench of the Honorable Madras High Court has held that a person not prosecuted for predicate offence can be prosecuted for the offence of money laundering in case of P. Rajendran versus Assistant Director Criminal. The court held it. Now your lordship mark it. The court never held it. But I have got the entire judgment, I got it. Now kindly see, learned counsel contended that when the accused in the predicate offence is the charge, acquitted or the proceeding against him or West, the prosecution under the PMLA cannot be maintained, which means that if a person is not prosecuted in the predicate offence, his position being far better than the former cannot be prosecuted under the PMLA. Now, paragraph 10 years quoted. At the first glance, this argument did appear convincing. However, the fallacy in the aforesaid submission was highlighted by Mr. N. Ramesh, learned special public prosecutor, who brought to our notice that paragraph number 253 and 467D of the judgment of the Supreme Court in Vijay Madanlal case deals with only the case of person named as accused in the predicate offence against whom the prosecution in the predicate offence is quashed or his discharge executed. This benefit cannot be extended to a person who has not been aired as an accused in the predicate offence because the offence under the PMLA is a standalone offence and is different and distinct from the predicate offence. Paragraph 11. Learned special public prosecutor submitted For generating proceeds of crime, a civil offence must have been committed after the commission of the civil offence and generation of proceeds of crime. Different person can join the main accused either as a abettors or a conspirators for committing the offence of money laundering by helping in laundering the proceeds of crime. Such person may not be involved in the original criminal activity that has resulted in the generation of the proceeds of crime. Therefore, just because they were not prosecuted for the predicate offence, their prosecution for money laundering cannot be said to be illegal. There appears to be much force in the aforesaid submission, especially in the light of paragraph 271 of the judgment in Vijay Madangal case. Now kindly see, my lord, we have given a judgment of 14/9/22. Kindly see the judgment, my lord, for a moment. Now, yes, that your lordship will kindly see. Madras High Court. That particular, yes, that. 14/9. 14/9 lordship got it. Or P. Rajendran. Your lordship kindly see on the name P. Rajendran. 14/9. Kindly see on the top P. Rajendran.
Yes.
Lordship, this is what my learned friend has quoted. He has only quoted, but we got the judgment of this court. Now kindly see. Para 11, kindly see. Now kindly see. Turn to that judgment. See para 11. He quoted para 11, my lord. He quoted para 11, kindly see. And he did not quote the entire paragraph. Only he quoted of his choice, my lord. I am not saying my learned friend is choice of the ED. And choice of the ED. Kindly see. My lord, kindly see. Now see case. Case, kindly see the last paragraph. In the light of paragraph 271 of the judgment Vijay Madangal case Supra, which is now this is kind, which is extracted below. What is 271? Kindly read now. As mentioned earlier, the rudimentary understanding of money laundering is that there are three generally accepted stages of money laundering. They are placement, which is to move the funds from direct association of the crime. Number B, layering, which is disguising the trail to foil pursuit. Number C, integration, which is making the money available to the criminal from what seems to legitimate source. No, my lord, there is no direct allegation.
Sir,
No, my lord, kindly see. Further, kindly see. 12. Kindly see para 12. Now in his 25 page. That apart, paragraph number 467D of Vijay Madangal case only speaks about discharge acquittal or question of proceeding of the accused in the predicate offence and the consequences that will follow for him in the PMLA prosecution. In that context, Supreme Court has held such an accused cannot be prosecuted under PMLA if the case against him in the predicate offence has been quashed or has been discharged acquitted. Now tomorrow, my lord, if your lordship finds that this person is not involved, directly or indirectly also, in that predicate offence. So there cannot be any case which they are registering. That's our whole case. That's why we are. Now, my lord, kindly take this second order, my lord, 14/10, my lord, kindly, second order, 14/10. Sonia, TD Sonia, kindly see TD Sonia.
Yes.
Lordship got it? This is same Madras High Court. Same. This judgment, paragraph 6, kindly see. This judgment was relied, paragraph 6. See paragraph 6, my lord. Paragraph 6.
Be carefully.
Be careful. Consider the aforesaid submission of learned senior counsel. We are unable to countenance the same. This issue was considered by this very bench, answering against the accused in 19880. That is what we run. That's what your lordship is that my learned friend has quoted. So and so. Mr. Now this judgment went for an appeal, my lord. Now this judgment, TD Sony went for appeal before the Supreme Court, and that was stayed. Interim order has been passed. Now, my lord, This judgment which my learned friend has relied, that also was relied by Madras High Court in TD Sony's case and said, no, we are not touching TD Sony because already we have decided. That was, my lord, challenged before the Supreme Court and same plea was taken. Kindly see, my lord, that what you are watching today, same plea was taken. And kindly see the observation, my lord, by the Supreme Court that is passed on 23rd, I think, 2/12/2022. A small order, kindly see, my lord, in the given circumstances, at least there cannot be any prosecution against the present petitioner under section 3 and 4 of the PMLA. Issue notice, just in addition, further proceeding into prosecution for the present criminal settlement state until further. That's what exactly we have taken in this particular case. Same stand. Same stand we have taken, my lord. My lord will kindly see.
Or else can you take up today for final disposal?
No,
Entire
these
matter.
6 can be taken up, not 3, my lord. For interim order only. Limited only interim order, not for other. Only 6. No, only 6. Or if your lordship willing, your lordship can take up on Thursday also. If your lordship want to take 6. Only question of 6 I am telling. Not troubling the whole case, my lord. This will take some time.
No, this court is of the view that either you take up the case for final disposal, both the matters
Lordship will take up both the cases together.
today,
No, by God, there.
or else we'll fix for some other date. And they will not go into all this thing. We'll go for disposal and in the meantime, the earlier, whatever, this also covers the earlier.
No, this doesn't, 6 doesn't cover, my lord. 6 doesn't cover the earlier because 6 we file later on. When they file affidavit before the court, then we came to know that this person doesn't have any indirect also, they have not connection, no direct connection. Somehow they are being, my lord, your lordship will see. Somewhere other offense, gaming, betting, they are trying to connect. Now the section 3 is very clear. Only connection with the proceeds of the crime so far generated. So proceeds of the crime in predicate offense is Nagaland. Nagaland, my lord, what was the case? Nagaland case was that there was an HPZ token app. That was the view of the people. They said, this is the app. You invest this amount in this app. So suppose you put 5,000, you will get 10,000. Make a chain, put a chain on it. You find people, you will get also money. That way, my lord, this what they have done is this app they introduced. And this was only an investment app. That has nothing to gaming, betting, there's nothing to do with. Now they are connecting somewhere, my lord, length and breadth of India they have investigated. And they are trying to bring the gaming, betting in connection with predicate offense. This is what the Vijay Badal law. You cannot bring some other loan application, gaming, betting, which the present petitioner. Let us take the entire statement which has been made as true and correct. Whether they can connect me in respect of Nagaland, they cannot connect. They cannot connect me into this offense. So what does section 3 says, my lord? Section 3 is very clear. 2(1) is very clear. In respect of proceeds of the crime generated in respect of this particular offense. Out of the criminal activity. This is what it says. That is why your lordship see the apex for judgment, the order that there cannot be any so far as the petitioner, quasi petitioner, it doesn't fall under section 3 and 4 of the PMLA. So entire prosecution was taken. They, my lord, they try to lure these people in Nagaland. They invested on this app and this money has gone credited to a particular account, which is Lillian Technocap. Nothing to do with this petitioner, Lillian Technocap. That's what exactly what the FIR says. By the Nagaland, they investigated. And they say, what is the loss? Certain money they recovered. The loss is only 13 lakhs to be recovered. And today what they are saying it is 900 crores, 160 crores in relation to certain loan app, certain betting. How can you connect me? All those. Let us, for an example, true and correct case, I am involved in loan app. I am involved in betting. I am in gaming. 900 crores. Have there any connection with those predicate offense? That is the reason why we challenge this, my lord, by way of 6, when an affidavit was filed by them. I said, What is section 3, my lord?
We'll go for.
Just before Lordship.
So far as facts are,
Yes.
concerned, Lordship, my paragraph 5 will explain how he is connected.
It's okay. It's
Only
okay.
what I paid for the interim order, at least they should not file any complaint. That's undertaking should be given.
Lordship, in the presence of my learned senior friend, Lordship, that I assure the court, at least till the next day,
Right.
no
Complaint, no complaint. That's right. I assure.
with the rider, Lordship, he will cooperate with the investigation.
Yes.
He will cooperate with the investigation. Because sitting in Dubai, filing a case here, he wants to solve all the proceedings.
Both the cases.
Yeah, he's sitting in Dubai in both the cases. And he's calling all the proceedings. And this is state money. People are being cheated.
Let us do it. They will fix it for
But
final
interesting.
disposal. You choose the date.
They,
And
they will, my lord, let us, if you lordship issue a rule, then again there will be hearing columns will come. So let it come for admission in this case, and there will be endeavor in the
endeavor should dispose of it.
endeavor should be made to dispose of this case. By law, because the problem is that the better we finish is better for him also, for us also. We know where we stand. He also know where he stands. So maybe on the second week of first week.
If it can be on 8th, if my friend agrees.
8.
It is an
Mr. Did us learned counsel to the. Did us assisted by Mr.
As does.
As does learned counsel to the petitioner. You are for one.
6 to 2023.
Huh?
Read petition criminal. 6 2023. I'm respondent number 1.
Okay. In 12, in 3, you are not there.
I'm not there.
Okay.
Which one?
2 and 3 lordship, I request. In WP criminal 6,
6, you are 2 and 3.
2 and 3. lordship.
And WP criminal 3, 1, 2.
1, 2 he will represent.
1, he's in 6,
2 and
You-
3 I am
2
representing.
and 3. And writ petition 3,
I am representing.
all. On the prayer of the learned counsel to the parties, list this matter for admission hearing on
On 9th of May, October.
9th October, 9/10/2023. Mr. And we shall be met to dispose of the matter on the next date. Next paragraph. The interim order passed earlier shall continue.
And there will be undertaking given that they will not file a complaint.
With the rider, lordship.
We'll cooperate.
With the rider.
Please stop. The.
In 6.
Do I need to record that?
Yes, but that's.
Huh?
Well, I think that's your
Okay,
lordship.
that's it.
Record it better, my lord.
They must,
In 6.
Mr.
In 6.
RKD Chaudhary. In the afternoon 6,
6.
undertakes that no
Complaint.
complaint shall be filed till the next date.
Yes.
To the next date of
But lordship,
hearing
he
of
will
the
cooperate,
matter.
lordship.
Please stop. With a condition that the petitioner shall cooperate with the investigation. Please stop.
No
The
complaint in the ECI case. ECI. No
complaint in-
complaint should be filed in the ECI.
Lordship,
no complaints shall be filed in ECI case.
Yes.
In writ petition,
In big petition, yes.
yes. With a condition that the
And
petitioner
they will-
shall,
They will retain the case that in my case.
you retain the case there.
in the meantime, if my senior files any.
Yes, I'll give the progress.
Next paragraph, the petitioner shall cooperate with the investigation. It has to be balanced, no?
Yes.
Sir, it has to be balanced.
Yes, of course.
It has to, it should not be a one-way street.
Cannot be problem.
Two-way street should be there. The learned people shall retain the case diary. In the next
This is
day.
what I feel, this case is not a case of one day it will be over. That's what if subject to what my learned friend says.
You,
No, what is next date will it goes on. So what will happen now? If 6, I can start my case on 6. Then 9 will reply on 9th. Because I know very well this case is not a matter of one day.
Yes.
Your lordship has seen a voluminous. Let it
No, that's
proceed this way.
right. If you are ready, I can hear today also.
I am
Till
ready.
tomorrow.
The 6th, lordship, I will be out. of
At least
session.
2 days we will spend, can spend.
Only the problem, I was
Or
willing,
you want to
my
find
only
the
file a reply in 3.
Ah.
That's-
in repetition 3, the petitioner, the learned counsel with the petitioner is permitted to file affidavit in reply. You just give the date.
What I was suggesting, my lord, if 6th I can, because I know, because.
Yeah, we'll
again,
fix, we'll start from 6.
I will start the case, then if somebody can note down, and 9th, he will come and give a reply, I can also give a reply, thereafter I have to give a reply. So I'm saying that's not a matter, my lord, we see that he is a voluminous of all these cases. I have to argue all the judgments of the Supreme Court also.
But
That's fine,
if
lordship.
if it is before this court, I just heard the facts and the law, whatever is required.
Yes.
That's why some of the learned member may not be happy with me. Why to, I mean,
My lord, I can start the case.
we understand the senior lawyers, you can argue for a month together,
No, nowadays, my lord, I have seen.
but we have started to stop.
Nowadays, that my lord, system of months has gone. That's why I was just watching. all
It has to
this-
be precise.
Precise, and what is,
And to the
I think
point.
time has come to our court also. There's some, like this type of matters where section 317 is an interpretation, my lord. So let us formulate what are the points for determination. Other side also, that particular, that what makes, my lord.
Or
It-
for convenient, you can come up with the written submission also.
Yes, if, my lord, there are some lawyers, there's 370.
Instead of fixing it for written submission,
We can.
before you start the
No, I will, I have
argument,
already,
you
my
can,
lord,
you
I have
have that synopsis,
I
I
have
mean, the
already,
brief of the
I
matter.
have already done this homework.
Okay.
What are the point for determination
Yes.
before this court?
Yes,
Because, my lord, this is an interpretation of 17 and that's
Ah.
not been decided by the apex court. This has not been decided, 17 has not been decided in a PMLA.
this court would love to hear this matter.
Yes, 17, my lord, this will be,
But-
honestly, I'm telling my lord, this apex court in Vijay Mandal has decided, but 17, search and seizure, interpretation not been decided. My learned friend is saying 17(2), when it is gone for search and seizure.
So there is a scope of deciding that, interpreting that section by this court.
This is the first time that new issue will be decided, my lord, first time. First time it will be decided. I search entire purely question of law. If your lordship decide in favor, then my lord, entire thing goes, search and seizure goes. ECR section 3 and 4. There's a predicate offense if you cannot connect. That's the whole. My lord, I may be a big fraudster. This is what is a fraudster involving 900 crores, 1600 crores, but if they cannot connect.
No, that apart from legality and technicality, we should not encourage.
No, we
Fraudster.
can't. My lord, I am saying, why I am saying, I have to be honest to be my argument, my lord. That's why I'm saying. I will never, but a lawyer, my lord,
Otherwise, society will be in chaos.
my lord, who will come? Somebody has to come and.
I understand. Okay, on 6th or
6th,
9th,
my lord, let it 6th, it remain on 6th. The matter I should start the matter. Because again, the problem 9th again will start, then again, let it 6th will start. My learned friend has some difficulty in 9th.
so
Let it
there
mute it
will be-
down.
two separate orders in both the writ petition.
Lordship, I have just one.
Let this both matter be taken up.
6th, 7th, lordship, I will be out of station, but my colleague will be here, he will take them. also.
Yes, no problem, absolutely.
Okay. You just, you make your own
Yes.
arrangement. Okay, then fix
On
on 6th,
6th,
huh? For the matter.
6th and 9th, my learned.
Ninth,
9th, you will also can note down. 9th, he will give a reply.
Then it's okay, we'll fix on 6th.
Yes.
Then you may make a mention on that day. Or your
Yes.
friend can make a mention that you should be allowed to, you may be given, I mean, to reply on 9th. That can be made
Yes.
on that day only.
And in the meantime, affidavit reply file, I'll submit
Yes.
to my learned.
Now, I have already I've said, is it been permitted to file affidavit in reply?
That
In-
way he's,
Ah.
I have to say he's very good.
Ah.
Give
Okay.
it to me 2-3 days before. From next.
For those item number 20.
Twenty. Last occasion, nobody appears. What to be done? What is to be done today?
Your lordship, the applicant would like to withdraw the appeal. Since during the pendency of the case, his sentence was already completed.
Okay.
Yeah.
So we can allow.
So, yeah. The applicant.
You have another one. You have completed sentence.
Yes.
Mr. So-and-so learned counsel for the appellant submits that during the pendency of this criminal appeal, the sentence for a sentence by the court, the accused has already undergone the complete sentence. Therefore, phrase for allow this to be withdrawn. Praise the Lord. This criminal appeal is closed on withdrawal. You just write her name also, MS Vance for learned PP.
For here, item number 22.
Please, Lord.
Yes.
Possibly this is a very short matter, lordship.
Ah.
I'm seeking only for. My apologies, Lord. One.
What is the matter about?
It's regularization, lordship.
Regulation for the post of?
Legal consultant, lordship.
Huh?
Legal consultant in the Department of Prisons.
What is the rule?
My learned friend is. The government advocate is not here.
On what basis you are seeking regularization?
Lordship,
Just because the post has been created, you are working on contract basis.
yes, I was working, I was appointed in the year.
That's what I'm saying. What is the basis of seeking regularization?
Lordship, a post was created, there's a post vacancy.
Doesn't matter.
Yes, sorry. I'll satisfy your lordship. But in the meantime, post was created. And because the prison department thought that it is necessary to have someone who is conversant with law. So she has been working, the petitioner has been working since the year 2029. And the department thought that they need a legal expert who is conversant with law. So that is why the representation was submitted by the department for creation of a post. A post was created by the cabinet. However, she was appointed only on contract, on ad hoc basis, on contract basis. Though the post has been created. So that is why I'm challenging the order of the government. In short.
No, that's why I'm asking. What is the basis? Why you should be regularized?
I'm not saying that I should be regularized. What I'm saying is there is a post that has been duly sanctioned by the government. So either I will be regularized or the post be advertised.
No,
Because the post is
another problem. We cannot direct it to be fill up the post.
What I want
It's
to
up
say
to-
is,
it's up to the
what I want to say
government.
is, lordship,
Creation doesn't matter.
Yes, there is a.
They may create so many posts,
So
but
there
then
is-
they may
there is
take
a
a
post, there is a
decision
particular
not to
So
fill up.
it should be either fill up or there should be a regular process. It's still lying vacant. it's
No,
still
that's
clear.
why we cannot. Court cannot direct to fill up the post. It is up to the government.
Yes, Lordship, it is there, but in there is a sanction post and post is still lying. So not only the petitioner, but let other letter who are eligible, they also participate in the selection process. That is what I want to say, Lordship.
No, if they decide to fill up, then only you can direct. Since creation doesn't
Direction,
create doesn't.
direction, Lordship, direction that since there is cabinet has already created the post of legal consultant. So the post be filled up by way of replacement or by in what.
It has to be, it has to be.
Yes,
It's,
that is my
you
prayer.
there cannot be a direction to regularize you,
Yes, I'm not saying.
but at this same time, this code is also is handicapped if they decided not to fill it
What I
up.
wanted to say.
We
is-
just cannot
what
force them to fill up
I
the
want
post.
to say is, there
Yes.
is a post that has already been created. The post is lying vacant, it's a sanctioned post created by the cabinet. So
No, yeah.
let this.
Yagarbati, that is what I'm saying.
Yes.
We cannot force them to fill up the post.
Yes, that's why.
We cannot.
Yes, Lordship.
We cannot ask them to fill up the post. We cannot
And
force them.
What I want to say, inquiry should be met that this post should be filled up as soon as possible. Because there is
That
a-
will be.
It's basically direction, Lordship. I'm not saying-
I
I'm not saying that I should be appointed in the post. I'm not saying that. But I'm saying that regular process should be made as per the rules. As per the rules, let the post be advertised.
Where is the rule?
No. I'm not saying there is no rule. Okay, there is no rule also.
No, to fill up the
But
post,
since
no,
Since
That's
the
here,
post
just
is
wait.
here,
to fill up the post. How can this be filled up
yes,
when you don't have a rule? What is
No,
the rule?
no,
What is
no.
the rule?
No rule. Lord.
No rule.
There is no rule.
There may be the reason they are not filling it up.
But
On what basis they should be filled up?
the model code of conduct of the prison says that in all the prison, there should be a legal consultant.
It's okay.
There should be.
And how it's a requirement, there should be a legal consultant,
There should be a legal.
Legal consultant.
I'm sorry, law officer. Lord.
law officer.
Law officer. Lord.
Now, how this has to be filled up? There must be some recruitment rule.
That I'm not very sure, Lordship, but what
You
I'm
have-
saying is.
you have
that
to be
the
sure.
Post is being created, so let this post be advertised. And
That is the difficulty. We cannot direct them to fill up the post. We cannot force them to fill up unless they decide to
no,
fill up.
I'm not saying we cannot force, but I'm saying a direction if the post can be filled up through through advertisement and all eligible candidates. Otherwise, the post is like just like.
That is the requirement, but then you show me the rule. On what basis this can be filled up? You don't have the rules.
Under the prison rule, there is no this thing, but under the prison model code of conduct, it says that every prison they should have a law officer. That is all.
Sir, I have understood.
Yes, right.
There is a requirement of law officer.
Yes, right.
It has been created.
It has to be created
One post has been created.
Okay.
So you are working on contract basis.
on contract basis.
So if possible, you are asking that for regulation. If not, it has to fill up by a regular process.
Yes, that is what I want.
Regular selection process.
No.
That I've understood. Now you listen to me. You listen to this quote. Unless the government decides to fill up the post,
No.
just creation a post. Just because they have created a post, court cannot force them to fill it up.
Worship, the post.
That is the difficulty.
Post was created in the year 2014,
Doesn't matter.
so it's not more than 10 years. And the prison manual says that it is mandatory that you have a legal officer.
It's okay.
So
Okay.
what Worship, I'm not asking.
Where does it say? Where is
Demanding that.
where is the prison manual? Just show me that requirement.
Worship, I have not annexed the prison manual. Yes.
No, how you are the documents which is not before this court, how you can rely on?
I have annexed, but I am not annexed the full this thing. If my lord may come to. If my lord may come to page 45 of my petition.
45.
Yes. Sir. Also, this is a letter issued by the government of India, Ministry of Home Affairs, the 1st March 2018. Says to the principal secretary home of all states and union territory. IG prison of all states duty. Subject. Recommendations of the Parliamentary Standing Committee on Environment of Women on.
What's the record, the relevant para?
Relevant is 46.
Huh?
46.
Ah.
Page 46 project.
Hmm.
MHA suggestion
Yes.
guidance. The state government and UT administration are requested to take note of the guidelines, which has been shared with them on earlier occasions and are also available on MHA website, and make best efforts to reduce under-trial prisoners in the jail, which will help in reducing the overcrowding in prisons, which in turn can bring a positive change in jail administration. The government of India has also issued an advisory which provides to steps to be taken up by the state duty to provide free legal aid to the under-trial, setting up Lok Adla special court in prison for expediting review of cases of the under-trials. The state government are requested to make best use of this and elevate the suffering of the under-trial prisoners. These advisories are also available on MHA website. Based on the letter, then Lordship, page 47. Rebecca, Lordship, these are all guidelines.
Where does it say that law officers, there should be a law officer?
If my lordship may come to page 49, lordship, page 49, and suggestion guidelines to be part-3. MHA suggestions guidelines. State should make efforts. Lordship, oh my God.
No.
To be more precise, lordship, if my lordship may come to page 50. Page 50, lordship.
Yes.
Yes, if I lordship come to page 50. This will be more precise to the page 50. That is MHA suggestions guidelines. Very lordship.
It doesn't say particularly law officer.
It does not particularly say, but if my lordship, I mean, we allow to read this NHS suggestion guidelines. Vacancies in prisons across the country need to be filled up in a time-bound manner to ensure focused intervention by counselors psychiatrist, welfare officer, and others. Then after that, A. Lordship, they may come to A.
You wanted this others,
And assessment of the required strength of all categories of the staff of all levels.
the law officer should be read into within the others.
Counselors,
Huh?
counselors, should be with counselors.
Are you a counselor?
No, I am law officer.
Then
Lordship, there is no such post as that. So what happened is, Lordship, if my Lordship may kindly come to you. There is only one law officer with under a department, and she is looking after.
you are still serving.
My Lordship may kindly come to you.
You were appointed on 12th November 2014.
If my Lordship may kindly come to page 30. Page 30. Of my petition, Lordship.
Three zero.
30.
Yes.
Then at para 10, Lordship, at the bottom, Riley Foreign Legal Officer. This is the petitioner. So she is looking after all this. She is the only person with a low background, and she is looking after all this under the department. That is, one is nodal officer for all judicial matters, including matters of the Honorable Supreme Court of India and all high courts. Two, nodal officer and member of Supreme Court Legal Services Committee. Three, nodal officer of Legal Service Authority. Four, nodal officer for prison portal functionaries. Five, action taken report on combination direction of the Honorable Court, Ministry of Home Affairs, and other statutory bodies, including NHRC, NSW, Model Prison Manual 2016, Prison Statistic of India. 9, prisoner matters in connection to legal matters. 9, inquiry, discipline, and suspending cases. 10, matters relating to the sport of visitors and non-official visitors. 11, file will be related to the supervision of the IT prison. So though she is on contract basis, Lordship, she is looking after all this matter, and she is the only person, person who is looking after all the legal matters, Lordship. And in fact, she is overloaded with her work also.
Where is the post creation? Page 32.
Sorry, I'm sorry, but page 32, page 32 is. And it's 11.
Yes, it's okay. Yes, sir.
And Lordship, I'm very sure I have just one copy. I just received it under the Prison Management Bill 1998. The Prisons Management Bill 1998. It especially says laws. There should be a law for the prison department. For the bill as sweetly provided, there should be a law officer for all the prisons.
It's a bill.
It's a bill, yes.
Has it been passed in the?
It's only a bill, yes.
Huh?
It has not been passed. It is only a bill.
Huh?
It's only a bill, yes.
Bill has not been passed.
No, no, yes.
No act.
No, I has been passed.
In that case, we cannot rely.
Lordship, as I said, it's only a bill, and this has not been passed in the parliament.
Yes.
No, your lordship, my only submission is that where is the possible legal right that has been violated by the state for the petitioner to come to this court, for this court, seeking for abandonment, no one. Because your lordship,
Use the mic.
your lordship, there is no violation of the petitioner's legal right. So the petition itself is not maintainable from the threshold. Your lordship, cabinet has created the post of a legal officer, law officer, or whatever by the name it is called, on the basis of contract. And petitioner was accordingly appointed on contract. So when a person is on a contract, how can the post be advertised? She was appointed way back in 2008, before the creation of the post on contract by the cabinet, by the state. Way back in 2008, petitioner was there as a legal officer on retainer basis, You know, your lordship can kindly see how the post was created. How the post was created by the cabinet. Lordship, you will find in page 13 of the state council. In page 13 of the state council, you will find the creation of the post. Skill of pay is there. But creation was not a regular post. It was on contract basis.
Yes.
So should come to page 14. Page 13, your lordship, is the creation of the post by the cabinet. State cabinet, and page 14 is the appointment of the lordship. Appointment of the petitioner as a legal officer. So your lordship, so since 2014, petitioner is executing her service in that capacity. Till today.
Page 16, his appointment was he or she? Petitioner, he or she? She. She was initially for 6 months. And you have been allowed to continue him till today.
Yes,
It's my lordship mechanic. Bear with me, lordship. My affidavit reply. In my affidavit reply, lordship. affidavit applied page 9, Annex 20. It says, this is dated 16/2/2021.
Have you completed your
Otherwise, I could say, otherwise I could say that the case of the petitioner is hit by the Umar TV case, actually.
She is.
So my only question is, what enforceable legal right that the state has been violated?
My lordship, I can see this.
The lordship see the right of the petitioner to recognize his service.
It's okay, I've seen it. There cannot be a direction for regularization, but then
When the cabinet has graded, when the state has
when-
graded the post for appointment and contract, how can that the petitioner may now turn around and say that his service?
you may take a decision, but then once this post is created, why you should have that kind of, it should be on contract? Why don't you fill
Yes,
up regular?
that is my prayer, lordship.
Allowing all the eligible candidates to participate.
In that case, your lordship challenged the cabinet decision of 2014. Where the cabinet has
If my lordship,
graded only for contract.
if my lordship, I can bear with me, my affidavit in reply.
There is a judgment of the Supreme Court. The court cannot force the state to fill up the post. Do you have that?
Then my lordship, I can go to my affidavit in reply.
Just wait, just wait. We'll let him complete.
Lordship, that is my only thing. That is my only thing. Because petitioner wants to be regularized or to advertise the post. When the creation itself is on contract only, how can that be? It's impossible, your lordship.
But the post is, you require the post. It's an important post for the state.
It's an important post, I agree. Then
It's a
petitioner
present
should challenge the cabinet decision of
present department.
she is there. Petitioner is there, executing his work. As has been assigned. to the
But
petitioner.
think about her, the future. There's a uncertainty. Uncertainty about the job, I mean, future.
So if if the petitioner feels that it is uncertain, then they challenge the cabinet decision.
Because
Decision
the
of the post.
post is important for the state, especially prison department. And there are guidelines by the Minister of Home Affairs, Government of India, to fill up the post. And if you want to function it properly, it has to be a regular post. You fill it up.
Now, your lordship, now we're in the reading of my.
Umar
I'm saying that the post should be on
Umar-
regular basis.
Umar Devi also says you cannot allow to continue on contract basis for all time to come. Since 2009, let us take it 2014. It's nearly 10 years, 9 years.
Lord, lordship.
If you don't require the her thing, you may discontinue. But you are allowing her to continue on contract basis for so many years.
No.
Therefore, it shows that you require the post, the person.
Yes, lordship, that's what.
Just wait. Therefore, why don't you fill up the post on regular basis?
No, my problem.
Once it is sanctioned, but
No.
cabinet said so, it should be appointed on contract basis. Cabinet approved the sanction
Correct,
creation.
correct,
It's become a thing, but appointment should be on contract basis.
correct.
That point of time in 2014, at nearly 10 years, she has been allowed to continue for nearly 10 years.
Correct.
There is a requirement of post has been created. You fill up it, will not direct you to regularize her service. She may not have that. But she can also participate once there's a selection, proper selection process.
For that, your lordship, no problem, but then whoever comes.
No,
Whoever comes.
will not direct,
Must be on
will
contract.
not direct
Okay.
state authority to regularize her service. That is not permissible. But then we may direct because facts and circumstances.
Correct.
You read the cabinet decision. It says approve with a condition that the appointment shall be contract. Huh?
Right.
Is it so?
And Lordship, in the meantime, she has been promoted to the board of Deputy Director.
Huh?
If my Lordship has seen my affidavit in reply.
She has been promoted
Yes, my affidavit in reply, Lordship.
without regularizing.
Yes, Lordship.
Without regularizing her service.
Indeed, her service. If my Lordship may kindly see my affidavit in reply.
This is something. Something is strange.
Because the problem.
How can she be
Yes,
promoted?
Lordship. But because of her efficiency in the work and department need the service.
See, you read your page 13. The cabinet approved the proposal of the Home Department for creation of the post of legal officer under present department on the condition that the appointment made to the post would be on contract. Appointment is only for contract.
In the similar manner of appointment of certain councils of the government. For the government, the Supreme Court.
Yes.
That means same as we.
That
all
point
people.
of time, cabinet has approved the creation. Creation is one part.
Yes.
Approved the creation. Post has been created, but appointment should be on contract basis. That is the decision of the cabinet.
So when.
And
there's a
surprisingly, when her service is not regularized, just show me where it is.
My affidavit in reply, Lordship. Page 9, affidavit in reply. The last paragraph.
Srimati so-and-so
Where the permanent legal officer.
shall hold additional charge of deputy director, prison. In addition, how normally, no, it is not a promotion. It's whole entrusting you of additional charge.
She is now deputy director.
Holding charge is
Holding
something,
charge,
it's not a promotion.
It's not a promotion, Lordship. Sorry, I'm sorry. It's not a promotion, she is holding the charge.
Yes, Mohan, fill up the post in accordance with law.
That is what I'm saying, Lordship. I'm saying that since there is a vacant post, there is a sanction post.
We cannot direct you to regularize her service, but you will fill up the post.
Yes, Lordship. That is what I'm saying, Lordship. Because she has been working since 2008. And with no condition on fixed pay, of course, now she is enjoying the skill pay. But the post cannot remain like that since there is a sanction post. It should be filled up by one way or other.
But there is a difficulty in view of the judgment of the Supreme Court or the law, settled law, that court cannot force the government to fill up the post.
What I'm not saying that. What I want to say is an endeavor should be made to fill up the post since there's a sanction post. An endeavor should be made to fill up the post. I'm not saying I should be appointed.
So that they may or they may not.
Yes.
In that case, we'll
But your lordship, whoever comes must come on contract only, because the creation itself is contract.
No, it's a second post, Lordship. It's a second post.
It's a sanction post. Appointment is only on contract basis.
Post is sanctioned.
So we're not issuing any.
It may be me or it may be any other.
We'll not issue a mandamus. We'll give a liberty to fill up the post in accordance with the law in view of the facts and circumstances of this matter. Attending facts of this matter. All right. We cannot accept her prayer, but then liberty will be given to you so that you let your wisdom prevail. Okay.
Yes.
Call. You are initially appointed as
legal consultant.
Huh?
Legal consultant. My lordship, may kindly see that my synopsis with petition. Her education is BA LLB. She has been practicing in the High Court for for a few years. And she got another legal counsel in the year 2009.
Yes. Mr. Younger Bhatt, learned counsel for the petition. Also, Mr. Moa Imchen, learned senior government advocate for the state respondents. By by filing this petition, the petitioner has prayed for a direction to the respondent authorities for regulation of her service to a post which has been created by the state on the basis of her length of service as well as a recommendation of the Department of Prisons. As she has attained all the eligibility criteria as per the model prisons manual. Next paragraph. The yes, a brief facts of the case is that the petitioner, which having BA LLB degree, was appointed as legal consultant in the year, which date, where you have mentioned that, where is that appointment? On on 27/8/2009 under the Department of Prisons, Government of Nagaland. The said engagement as legal consultant was on retainer basis. Essentially to serve, preserve, book the legal practitioner service, to be made available at a future date for a fee being paid in advance. Next paragraph. Was your appointment order? First appointment order, second appointment order?
Lordship, there is only extension order.
Huh?
Extension order.
No.
Page 1.
Page 33 is what?
It's
This is the appointment order.
this is
before-
also
before
this is
the-
also extension order. Sir.
Next paragraph.
Extension order.
Before that. Well, the petitioner was serving as legal consultant. A proposal was mooted through memorandum dated 10/01/2013 for creation of one post of legal officers. Since the rate of litigation has been on the increase with the increasing crimes in the state. With the growing concern for the human rights, the National Human Rights Commission has issued directives for having a legal officer in the prisons organization set up. And as per the Model Prison Manual and the Prison Management Bill 1998, a post of legal officer is mandatory. Mr. Next paragraph. What is that cabinet decision? You have not annexed the cabinet decision.
Page 32, Lord.
Huh?
Page 32 of my petition.
No, it's not a cabinet decision. It's an order creation of.
It's a notification
What?
covering the approval.
No, where is that? Mr. Moore? Cabinet decision. The White Office Memorandum dated 30/9/2014. The state cabinet has approved the proposal of the Home Department for creation of the post of legal officer under the prison department on the condition that the appointment made to the post would be on contract. Mr. By notification thereafter, continue. By notification that it this is notification number HOME, HOME, capital /JL-2/ESTT/1/12/241 dated 11/11/2014. The post of legal officer
Your lordship will find the
Was-
proposal in page 7.
was created post of legal officer +1 within bracket gazetted in the scale of page so and so, page 15 of affidavit, page 15 on affidavit. So and so. Next paragraph. Provide notification. Page 16, of affidavit. Number home oblique stop JL-2/1/12/242 dated 12/11/2014. The petitioner was appointed as legal officer +1 gazetted under the prisons department. In pursuant to the creation of the post on contract basis for an initial period of 6 months. It is noted that the service of the petitioner has been extended from time to time till date, for which she is serving as a legal officer on contract basis. What is page 18? It was placed before the cabinet.
Well, Rosh, we come to page 9 of the affidavit of the government.
Huh?
Affidavit of the government. Says the matter has been re-examined and we agree to the creation of one post of legal officer in so and so under supervision of the.
No, that has gone. Thereafter, you have been recommended for regulation, your service.
The department has recommended the department, but the government, they have.
Next, the Home Commissioner by cabinet memorandum number home /J-2 established /1 /122 12 dated, which date this is 25 October 25/10/2017 as let's the proposal for approval of the for decision of the cabinet for regulation of contract service in respect of the petitioner as a legal officer and the Director General Prison. The state cabinet by the office memorandum dated number CAB-2/2013 within bracket PT bracket close dated 19/10/2019 has considered the case of the petitioner for regulation of her service as legal officer under DG Prison and had decided the Home Department decided and directed the Home Department to first seek the views and comments of the Justice and Law Department, Justice and Law and PNR Department. The next paragraph. The Law Department as well as the PNR Department, PNR Department within bracket ONM branch with bracket close.
Your Lordship,
Has
findings of the day.
just wait. I find that in view of the order of the Honorable Gauhati High Court in WPC number 145K within bracket K. Which this is WPC 145K is which year? Nineteen.
Appeal is.
April is 19. What about the writ petition?
Lordship, with appeal, there was an appeal also. With appeal number.
I'm asking the year of WPC. Writ appeal I have seen is 2019.
I'm sorry, Lordship, here it is not. They have not mentioned the year of the petition. It's only said WPC number 145K. And there's
I've
no.
opined that in view of the Honorable Gauhati High Court order as well as in writ appeal number 16 within bracket K of 2019. The case of the petitioner cannot be considered, would not be possible to consider, which may invite contempt proceeding. Please stop. Moreover, the appointment of the petitioner is on contract basis, which she cannot be regularized in view of the judgment of the Honorable Supreme Court in the case of State of Karnataka versus Umadevi within bracket 3, bracket close, reported in 2006 for SCC, page 1. Thereafter, the next paragraph. Having not been considered for regularization, despite several approaches by the respondent authority, the petitioner has approached this court for a direction to the respondent authority for regulation of service as a legal officer, as the post has already been created and it's a sanctioned post. What is your submission? Mr. Yangirbati, Learned Counsel.
My various race post has already been created.
Mr. Yangirbati, Learned Counsel for the petitioner submits that
Since there's
though the prayer of the petitioner is for regulation of her service as a legal officer, legal officer who has been working since 2009.
Yes, ma'am.
Since 2009. No, you are working since 2014 as legal officer.
2009, yes.
Since working as legal consultant since 2009 and thereafter as legal officer since 2014. Fairly submits.
May allow me. In the meantime, she has also been additional charge of the.
Yes, fairly submits that in view of the law laid down by the Honorable Apex Court, the prayer may not be in tune with the constitutional provisions of public employment. However, he submits that since the post has been created and is a sanctioned post, and the facts of the case clearly reveals that the state requires the requires the service of the petitioner as in the post of legal officer. In accordance with the central government guidelines as well as human rights guidelines. Human Rights Commission's guideline.
And model prison manuals.
As well as model
Prison manual.
prison manual 1998. The state respondents may be directed to fill up the post in accordance with the law, in accordance with law. That's all. Facts we have recorded. Your submission is this one.
No.
You are not asking for regularization.
No, she, in fact, she has been working since 2099 and she maybe.
I said, though your prayer is for regularization.
Yes.
But then in view of the law later.
But are we satisfied if the post will be?
No, you
Maybe it's a petitioner, maybe some other person, qualified person.
That's right.
Let the post be filled up. That's what I want.
Next paragraph. Per contra, Mr. Moa M. Chen, senior government advocates for the state respondents, submits that though the post was created, but as per the cabinet decision, it has to be filled up on contract basis. Accordingly, the petitioner was appointed on contract basis. He submits that unless the cabinet decision is put to challenge, she doesn't have any rights to claim for regularization, as it is evident from the cabinet decision that the post has to be filled up on contract basis. Next paragraph. Mr. Moa Senior Counsel submits that the petitioner could not petitioner has not shown any violation of fundamental rights for any enforceable fundamental rights or fundamental or legal rights for which this court fundamental or legal rights to approach this court. He submits that though the post has been created, but the appointment is for contract basis, therefore the petitioner has no right to claim for regularization. That apart, it is a settled position of law that the contract appointee cannot claim for any regularization, which will be in the teeth of the various pronouncements of this court as well as the Honorable Supreme Court. Next paragraph. I have considered the rival submission of the counsel to the parties. Next paragraph. And the materials available on records. It is next paragraph. It is noticed that the state government has created a post for legal officer, which shows that the post is required to be required for the state in terms of the various attending facts and circumstances, including the guidelines and of the direction and guidelines of the Ministry of Home Affairs, Government of India, as well as National Human Rights Commission. It is also equally the materials also reveal that the post is required for the state, particularly prison department, as the petitioner has been engaged and been allowed to continue for last 15 years, since 2009. Firstly, as a legal consultant, thereafter as a legal officer on the post created by the state. On, of course, on though on contract basis. Next paragraph. On consideration of the various law laid down by the Honorable Apex Court as well as this court. This court is handicapped to issue such a direction. So it appears, though it appears that the post request to be filled up. At the same time, the court cannot direct the state respondents to fill up the post if the state has not decided to fill up the same. In other words, the court cannot compel the state to fill up the post, though there may be a existing vacancy or the sanctioned post. In such circumstances, this court is constrained to hold that the prayer of the petitioner for regularization of her service as legal officer cannot be accepted. It cannot be accepted. Therefore, there cannot be any direction for regularization the service of the writ petitioner. Next paragraph. However, in the attending fact situation, the state respondents are at liberty to fill up the post in accordance with the law.
On regular basis, since there's a sanction post.
No, we'll not say that. In accordance with law.
There is.
It includes all in accordance with law. With the above.
Possible. If my lordship may.
I said, we're handicapped. We cannot direct them to fill up.
Well, I'm not. I was saying that you should be direction, but expeditiously as possible.
We cannot compel.
Yes, but we cannot expeditiously as possible because I don't know how long the step will take up.
Allowing all the eligible.
Yes, lordship.
Candidates to participate in the selection process. With the above observations, this writ petition stands closed. I'm not disputing. No order is to post. I'll just modify your submission. We'll add something, huh? But sum and substance, your submission is that you have prayed for regularization.
Yes, lordship.
But then in view of this judgment, the law laid down by the FX court.
Yes,
your prayer is for fill up the post as it has been created. It is.
Since there's a vacant sanction post, it should be filled up.
Post.
It should be filled
in
up.
accordance with law. That will just modify. Huh? What submission just read out? His submission. Mr. Yangaberti Learning Council for the petition submits that.
Lordship, not till 2014, but till date. Okay, as because she is still serving till date.
No, we have recorded all. No, since there is a what you said, vacant, there's a vacancy. It's a vacant sanction post.
It's a sanction post and it's still vacant because it's not being filled up on a regular basis.
Since there is a regular sanction post of legal officer, the respondents may be directed to fill up the post in accordance with law.
Right.
That's all.
Right. Last message.
Yes.
For hearing. Item number 21.
Please, Lordship.
Yes. What is this?
Lordship, it is also for regularization, Lordship.
Which post?
It's serving as a driver, Lordship.
Huh?
Driver on workshop spaces, Lordship.
Okay.
It was a common policy, Lordship.
What about this judgment? Sri Alemba.
That is not relevant in my case, Lordship.
Huh?
That is not relevant, Lordship.
Then where they placed it? Nishibi Achumi. There cannot be regularization as such, no direction for regularization.
Lordship, there's a common policy, Lordship.
That common policy has been.
Even under the common policy also, he's not eligible, Your Lordship. Because according to the policy which is holding the field right now.
It's that you must be 30 years.
Yes, right now, he's below 30 years.
One point I agree with you. This court is totally agree with you. There cannot be division wise. It says about department. But the biggest hurdle, another problem which we are not, I mean, as she has admitted,
Yes,
you have to complete 30 years.
Yes,
You have only 27 years.
That is with regard to the office memorandum 2015, Lordship. There is also another office memorandum which is still holding the field, Lordship.
No.
In fact, for the last 19 years.
So bottom, it has to be read together
No, Lordship.
or separately.
No, Lordship.
Are you trying to say that this 2015 will not apply to you?
Yes, Lordship. I am admitting, Lordship. Though that 2015
regulation has to be done by now.
Yes, Lordship. I'm eligible.
How this can be?
In fact, the course of action and Lordship, I'm aggrieved, and it has been continued for several years, Lordship, altogether.
When did you become eligible?
Lordship, as in when the vacancy arises, Lordship. And I have already.
When was the vacancy arises?
Lordship, I have enclosed.
Is it before 2015?
Yes, Lordship. For the last 10 years, Lordship, I have enclosed the documents, the record, which clearly says that there are vacancies, Lordship.
Let us see your state policy. What does it is a policy?
May I refer to only the relevant policy, Lordship. If I read 2015, it will be West of this Honorable Court passage time, Lordship.
No,
she is not eligible, Lordship.
No, she said this will make the line.
Yes, Lordship.
The petitioner also categorically stated that this OM is holding the field, Your Lordship.
Yes.
Paragraph 8-9, Your Lordship. He's categorically stated that.
I'm not denying, Lordship. Both are holding the field, but I'm not eligible under 2015, Lordship. I have to complete 30 years. I admit the fact, Lordship.
Yeah.
I complete only 25 years this December, Lordship.
Yes. So you wait for that.
No, Lordship.
Complete
2004 I am still holding the field. If I may be allowed, Lordship, page 32. Just for a moment, Lordship. Page 32.
Let us see.
If the Lordship got it, this is annexure 8.
Yes. 2004.
Yes,
Hmm.
22nd of September 2004, Lordship.
Yes.
Policy and scheme for regularization of service of work church employees, Lordship.
Are you work church employee?
Very much, Lordship.
Okay.
There are
Yes.
large, may I read it, Lordship?
Yes, yes,
There are large numbers of work church employees in various departments.
yes.
Many of these employees have been serving continuously for many years. They have been representing to the government for regularization of the service. Some departments have been regularizing the service of work church employees from time to time against available vacancies. However, no transparent and rational policy and criteria is discernible in the process of regularization of service of work church employees. Therefore, in order to examine the issue of regularization of work church employees in various departments, the state government set up a committee under the chairmanship of so-and-so additional chief secretary. On the basis of the recommendations of the committee for regularization of work church employees in the state, the government hereby adopts the following policy and scheme for regularization of the service of work church employees serving under various departments of the state government. The first, Lordship, the Roman one, each department having work church employees should maintain a list of work church employees in various categories in order of the length of service. So this is important, Lordship. Second, regularization of work church employees will be done against available regular vacancies. There should be a seniority list, there should be regular vacancies, Lordship. Third, 50% of all regular vacancies of similar nature arising in a year. This is very important, Lordship. Available against regular vacancies will be reserved for regularization of work church employees, and the remaining 50% will be filled up as per normal rules of recruitment. So vacancy arises in any year, Lordship. 50% is reserved for work church employees, and the rest 50% through regular selection process, Lordship.
No more.
Lordship, if I may allow it to complete it, Lordship.
You try before some other match. I'll dismiss it.
Lordship,
2004.
yes, Lordship.
Then thereafter 2006.
Lordship.
Uma Devi.
Yes, Lordship.
You have seen it. There cannot be any direction for regularization.
Lordship has also rightly observed, Lordship, in the previous occasion, Lordship, the government also cannot continue to use my service. I have been serving for the last 25 years.
It's okay.
Just because I was appointed against.
That was in fact circumstances of that matter, because this
Of course, Lord.
prison and all, there are lots of things to be done.
If I'm allowed to rely on two authorities, possibilities and report similar situated cases, Lordship, same department, Lordship, same nature of appointment, Lordship, just that the posts are different, Lordship. I have not completed 30 years. Court has given direction, Lordship.
You have completed 30 years in that matter.
No, in that two matters, Lordship, which I'll be relying upon, Lordship.
Yes.
I've not completed 30 years. However, this honorable court has given direction to the respondents to regularize. In fact, they are being regularized after this direction of this honorable court. If I may be allowed to rely, Lordship. Same department and same nature of post.
Driver.
No, not driver, but on work church basis, Lordship. It covers my case, Lordship, 2004 as well as 2015. Lordship, how my case is covered under 15? In the year 2015, when the 15 was introduced, Lordship, this 50% reserved has been enhanced to 67% for a period of 5 years, Lordship. Because, Lordship, there are rampant appointments made, Lordship, from time to time. And this 50% reservation was
What is
Lordship.
what is the recruitment rule?
Recruitment is, Lordship, through in terms of the constitutional scheme for public employment, Lordship, it has to be advertised, Lordship.
There's no
That is the 50%, Lordship.
there's no separate thing.
However, the remaining 50% has to be regularized in terms of this policy, Lordship. Rightly or wrongly, it has not been under challenge, Lordship. And it is existing for the last 19 years.
I've come across somewhere that 2019 writ appeal, and there's maybe different, you also go through this.
Yes, Lordship. That is with regard to, Alamba is with regard to posthumous regularization, Lordship, posthumous regularization. There's no policy and scheme, I admit, Lordship, for posthumous regularization. However, Lordship, in this judgment, the Honorable Division Bench has discussed that 30 years is way too long for someone to serve, Lordship, to regularize, Lordship.
This one, which you are relying.
Yes, 2015 OM, Lordship. In fact, Lordship, this OM has been put under challenge, Lordship. My apologies, I don't remember the case number, but it is pending before the Honorable Court, 2015, which says that I have to complete 30 years of service. Which is totally arbitrary, Lordship.
Or you,
How can the government expect me to serve for 30 years in regularized on the verge of my retirement, Lordship? Some goes even before reaching 30 years on superannuation, Lordship. Which means their service will never be regularized, Lordship. Here in this case, I've completed 25 years of service. And this on code on time and again, cutting of decisions, Lordship. I'll be relying on 2 decisions, Lordship. They have not completed 30 years.
no, what about Uma Devi?
Lordship.
What about Uma Devi?
Lordship, I agree in principle, Lordship.
ML Kesri thereafter.
Yes, Lordship, ML Kesri 2010, Lordship. But this policy still holds the field, Lordship.
Policy cannot override the constitutional provision as well as the statutory provision.
In that case, Lordship, I may be allowed to try my luck with some other day.
Because I don't want to,
Yes, Lordship. Let me die some other day.
I don't want
Lordship.
to make you unhappy.
Lordship.
You go through all these cases,
Yes, Your Lordship.
this can be, I mean, policy decision as such cannot override. You may have, unless you are graciously accept it.
In fact, 2015 is
In certain cases, you have to argue on the basis of the law, which may go against you also, go against your action. That is the niceties of being a public service, like public servant, like state council. You should have a privilege and authority to argue in terms of the law, though it may go against the action of the state. You have to place the facts. So this policy, according to this court, should not sustain.
Lordship, just to apprise this honorable court.
Yes.
2015 OIM is in tune with Omadivis, Lordship. In fact, when this
2004,
15 Lordship, 15, when the office memorandum was framed in the year 2015 Lordship, it has to be 19 years, Lordship. Calculating the date, the dateline, 10th of April 2006, it has to be strictly in compliance with Omadivis decision, Lordship. 19 years. It completes 19 years in the year 2015. However, 30 years has been incorporated in the policy, Lordship.
it is still pending.
Lordship.
Challenges is still pending.
Yes, Lordship, it is still pending.
So you are relying on 2015.
Yes, Your Lordship.
Whatever 2004,
2004.
it has not been done away.
Your Lordship, even in Alemba, the Honorable Division Bench is discussed and they, according to their opinion, the 2015 holds the field, Your Lordship.
Also feel,
Yes,
not 2004.
Yes, Your Lordship.
Maybe in the facts of the matter.
Yes, Lordship.
He said there were vacancies before 2015. And he has not been considered just because he's not senior in certain.
Yes, Lordship.
Though he's senior in terms of in the department, but the post where it was vacant was in the division where he could not be considered. That is not the requirements of 2004 OM.
And
That
Lordship,
is
something that really questions the conscious, the conscience of Lordship. When I have also reproduced a chart in my affidavit in reply, Lordship. All along, Lordship, for more than 10 years, I'm in the second senior most position for the last 10 years. And I have reproduced the chart.
Whatever first one.
Yes, ma'am.
Yes, Lordship.
Yet to be regularized.
First
Yes,
has been
Lordship.
regularized.
No.
However, Lordship, there are vacancies, regular appointments made.
No, first has been regularized.
No, Lordship.
You are in second.
No, Lordship. As from 2019.
Then
Because that was the letter saying that 2019.
first will be taken up first.
Exactly, Lordship. I'm not saying that I should supersede,
So
Lordship.
we'll say that
But there are vacancies, regular appointments, 72 altogether, Lordship. 72. And if it is to be considered 50%.
it has been regularized. 72 persons have been regularized.
No, appointed on regular basis, Lordship.
Okay.
It shows that there were regular vacancies, Lordship.
No,
But 50% has not been complied.
We just cannot presume and assume. You have to
It
bring
is on
out.
record, Lordship. I have filed by way of an affidavit.
Yeah,
Lordship.
that's why you have to bring out.
And that is the information furnished through RTI, Lordship. By the department itself, Lordship.
74.
72, Lordship.
By way of regulation, by
Regular appointment, Lordship.
no, regular appointment is something different.
No, Lordship.
Whether it is a direct, by way of advertisement or just an appointment.
No advertisement.
You said 50% is for regularization of the, work.
Yes, Lordship.
And 50% direct recruitment.
Direct recruitment.
from the market.
So that shows that 72 regular vacancies were available, Lordship.
So 75%, how they have been appointed? Is it for as a by regularization or
Regular
direct
appointment.
recruit?
Regular appointment. I have specifically made.
No,
the
direct
point-
recruit or regular by regularization.
Direct recruitment, Lordship. Direct recruitment.
So you cannot
But
claim
it's
that
not by way of
50%.
regularization, Lordship.
If it is not by regularization, you cannot claim that post. 74, if it is by direct recruitment,
Lordship. Then 50% has to be reserved, Lordship.
your quota is 50%.
50% has to be reserved. And going by the ratio, at least 36 has to be regularized, Lordship. And I'm holding a second senior most, Lordship. If 36 are considered, automatically my case will be
So
considered.
another difficulty would be if we go that deep,
Lordship.
who are these 75 or 36%? They have to be party before this. If we say, if we had to say, if we had to say ki this 36%,
at least
I
an
mean,
observation.
post could have been filled up by what this regulation as per the OM. And this 36% has to be before this court. We cannot pass any
Yes, Lordship.
order.
This court takes cognizance of the 72 appointments. And if a direction can be issued that no such henceforth, no such appointments should be made without considering the 50% for regularization. That's
No,
how I may be considered in the future,
The
Lordship.
problem is 2015 is also there. Why conflict between 2015?
There's no conflict as such, Lordship. The only criteria need in this 2015 is I should complete 30 years.
Is it a kind of filling up the gap of 2004? Is it
More or less. Lordship.
by having a memorandum, office memorandum 2015, is it by filling the gap, which is not there in 2004? Or is it a supersession of 2004 OM?
The word supersession is not used, but 2015 is probably the Lordship, because in 2004, the quota was 50-50 for work charge and direct recruitment. But in 2015, it's 67 and.
Let us this judgment. Your judgment, let me have a look.
Lordship. What's the WPC 200 of 17, it was disposed of in the year 2017, and the second is 320, WPC 320, 2021 was disposed of on 20th of May 2022, Lordship. Both they have served for 25 years, Lordship, in this ordinary petitions.
In this 2021, government has no objection, did not object the direction. So,
Lordship.
in view of the earlier case.
Because you know the fact that they are not complying with the 2004 OM, Lordship.
No law has been laid down.
Of course, Lordship.
We may have,
The action was issued.
we may defer it.
Lordship.
Hmm?
Lordship. If your Lordship has a different opinion, let me.
I have a different opinion.
Lordship.
No regulation.
Lordship.
And if you have a policy also, suppose
Yes, Lordship.
the basis is of policy, I also have it. Because the policy
Policy
cannot
is purely on the basis of.
policy cannot, policy cannot have, it cannot override the statutory provision.
Lordship, 2015, it's not contrary with the direction of Umar Devi Lordship.
Hmm.
In fact, 10 years, Umar Devi said, 30 years has been laid down by the state Lordship.
Policy, I'm not saying that you cannot have a policy, but policy has to be in consonance with the constitutional provision,
Lordship.
as well as the statutory provision. Sorry.
Lordship. Much pleasure. Lordship.
Next.
Item number 3.
Oh. Just ask more. So and so. What do you want? Sorry. On the Mr. Moed, the petitioner, and also her MS Esmeralda council
In our language.
in our land council. State respondents. On the prayer of the land council for the petition, list this matter after 3 weeks.
Please.
Please, your lordship.
Yes,
Lordship, here the petitioner is praying for family pension
yes,
and pensionary benefits out of the service of her late husband.
okay.
And the present
The
petitioner,
problem is, what is your service book? You have lost the service book.
that for that your lordship, it is not with the petitioner.
Huh?
Your lordship,
Is it the
I
case that
know
you have
your lordship
lost the service book?
not
Which
the,
is
not the service book, the PPO book, your lordship,
PPO book, whatever.
but a copy of the service book is also not with the petitioner.
See, who is appearing for the AG? You are.
Yes.
This court has directed you, both the state and the AG, Accountant General, to clarify who is responsible for all this thing. You are still, by filing the additional affidavit, you are still making a same submission. Neither here nor there. Just passing the buck.
But without receiving any relevant documents from the petitioner, the AG cannot proceed with the pension documents.
Then they said they have already weeded it out. The records, which is permissible under the rules. This has been weeded out by the government. So in such a situation, can we allow the petitioner to suffer? What is the solution? There must be something.
Lordship, kindly come to.
I have seen both your affidavits. It doesn't solve the problem. Let us have some solution on it. Government, what is to be done?
On the last occasion, the petitioner. had
You just,
submitted- On the last occasion, the petitioner had submitted one OM. I don't know whether she still has that copy.
OM. Spell. Yes, office memorandum.
Lordship, office memorandum dated 13 July 2015.
Yes,
Mr. Lordship.
what does it say?
Your Lordship, with regard to the inclusion or change of nominee
Hmm,
for the purpose of family pension after the death of the pensioners, Your Lordship.
hmm. Hmm,
A proper inquiry has to be conducted by the Deputy Commissioner for authentication, Your Lordship. However, in the present case, the petitioner has not done that.
you are,
Your Lordship,
who you are?
the petitioner is the second wife. of-
Second wife.
Yes,
Where is the first wife?
the first wife, she has expired.
They expired.
Yes, Your Lordship.
So your name has not been,
Yes, my name, as per the service reports, my name has not been nominated, Your Lordship.
okay.
However, with regard to that, it has come to my knowledge only after the state respondent number 5, the accountant general, they have filed their affidavit. Because,
That she's not a nominee.
yes, Your Lordship.
Ah,
So it was only after they have filed their affidavit, Your Lordship, it has come to my knowledge that my name has not been nominated as per the service report.
who are the nominate,
The first wife has been nominated, Your Lordship.
nominees, only first wife.
Yes, the name of the petitioner as well as her daughter is not a part of the record furnished to the office of the deponent as the adoptee of late T.K. Gopalan.
Hmm. Who are the nominees? Who are the nominees?
First wife, Lordship,
Only,
yes, Lordship.
she had no issue. No son, no daughter.
No.
First wife, from first wife.
No, Your Lordship, Mr. Let T.K. Gopalan, the husband of the petitioner. The husband of the petitioner has married the petitioner after the dissolution of his marriage with his first wife, Your Lordship. And they have been living together for some few years, and before the name of the petitioner was nominated, I believe he has expired, Your Lordship.
What you have received as on today? Have you received anything?
Yes, Your Lordship, after my husband has expired, I have applied for a succession certificate before the petitioner. That was back in the year 1985.
No, apart from succession certificate,
Yes, Your Lordship, and it was,
any benefits, retirement benefits?
yes, Your Lordship, I have received family pension for some few months, but unfortunately, I have lost a copy of the PPO book, Your Lordship, and has been unable to obtain it till today. And on several occasions, the petitioner has, through her counsel, filed an RTI before the state respondents to obtain to furnish the service records of my husband, Your Lordship. However, they were unable to furnish it, Your Lordship.
What is the rule?
Service reports, Your Lordship.
What is the rule in such a situation? If you have lost it,
Yes, Your Lordship.
and if they don't have, because they have weeded out these documents as per the rules, 12 years or 15 years, it has been weeded out. And unless the state government gives to the AG all these papers,
Yes, Your Lordship.
which has been weeded out, I mean, they cannot, once it is weeded out, they can also give it to the AG. AG said that we cannot do anything. Is it your stand? Unless state government submits a paper to you, you cannot do anything. But they said, once it goes to you, they don't have anything to do.
Lordship,
In fact, it's your fault only. You have lost it. They have waited out the documents long back. How they will give
Your
you?
Lordship, I have, along with my succession certificate, Your Lordship, and documents, the service records of my husband, I have submitted it before the AG. However, it was Tempo has lost it, Your Lordship. And for that, I also have the AG receipt number, Your Lordship. After submitting by my original documents, I have approached the office.
You have multifarious problem. First, you have lost your documents. Second, you are not the nominee. Huh? Isn't it?
Yes, Your Lordship.
Third, they have withheld the documents. Fourth, unless state government gives it, Accountant General cannot do anything. Office of the Accountant General. How to go with it? Tell us.
Lordship, the petitioner has lost their service book, and as per the as for the
Are you saying she is not entitled?
yes, Lordship.
Are you saying that she is not entitled to receive all this pension? I mean, the family pension and all?
No, Lordship, but
What you are saying?
the petitioner has already lost their service book, so the Accountant General cannot proceed without the relevant documents.
What to
Your
do?
Lordship, it is my humble submission that there is no dispute regard to the fact that the petitioner, the present petitioner is the wife. Also, Your Lordship, as per this office memorandum, with regard to the change of nominee and inclusion of their name, Your Lordship, I may be.
Have you asked for change change of the nominee?
No, Your Lordship, it is only after I have approached this honorable court
Yes.
and after seeing the affidavit filed by the state, by the Accountant General, it has come to my knowledge that my name has not been nominated. So, Your Lordship, I may be allowed to accordingly approach the Deputy Commissioner as per this office memorandum, Your Lordship. This is my humble submission.
To approach the Deputy Commissioner?
Yes, Your Lordship.
Okay, in that case, it's okay.
To be fair, that's the only solution right now because the petitioner does not have any documents with her right now. And she's saying that
she has at least the succession certificate.
Yes, Lord. And she's saying that the first marriage has been dissolved, but there's no document to prove that also. And it's just her statement saying that the first wife has expired. Nothing to prove, just a statement.
She's fair enough. She said she may be allowed to approach the Deputy Commissioner.
yes,
Will there be
that's
any
right.
problem? Will it resolve your problem?
I believe so,
Approaching
Your
the
Lordship.
Deputy Commissioner?
Because even under the CCS pension rules, there is no bar
You can
for the
approach.
second wife to enjoy family pension, Your Lordship.
So you want to approach the Deputy Commissioner?
Yes, Your Lordship.
Okay. Because of this.
Yes, Your Lordship, as per this office memorandum.
So we'll not give the detailed one. We'll just record your submission in view of this office memorandum.
Yes, Your Lordship.
Heard MS so-and-so learned counsel for the petitioner and also heard MS, who is number one? You. So-and-so learned counsel, state counsel, and MS so-and-so for respondent number 5. Huh? Next, by filing this petition, the petitioner has prayed for for a direction to release the family pension and pensioner benefits arising out of the service of her late husband T.K. Gopalan, who was serving as a supervisor, police radio, Mokuksha, Nagaland. Mr. Next paragraph. The petitioner claims to be the second wife of the late T.K. Gopalan. Who had married up to the after the death of the first wife or after the divorce of the first wife?
Your Lordship.
You married after the death of the first wife?
After her death, no, after the dissolution of the first
Okay.
marriage.
After the dissolution of marriage of the first wife of late T.K. Gopalan, Mr. Her late husband expired on 24/12/1984, leaving behind a petitioner and their then minor daughters, minor daughter, Mr. C. The petitioner claims to have received family pension for about 6 to 10 months following her husband's demise. Just the day after, unfortunately, she lost a copy of the pension book. Pension book, it is pension book,
Yes, Your Lordship.
and had been unable to find the same till then. Petition also claims that she had been granted the succession certificate by the Deputy Commissioner Makuk on 8/1/2006. The petitioner has approached the respondent authorities for family pensions since she has lost the copy of the pension book. However, same could not be materialized. Mr. That being agreed, the petitioner filed the writ petition number 106K of 2017 before this court, which was withdrawn on 28/3/2018 with a liberty to file afresh. Thereafter, she filed a declaratory suit before the learned JMFC Mokuksha, being declaratory suit number 4 of 2021. However, the suit was rejected on 12/8/2021 on technical ground of deficiency in court fees. Thereafter, hence this petition for a direction to release the pension, family pension and pensionable benefits arising out of service of harassment, late TK component. I'm a so learned counsel for the petitioner submits that there's no dispute that the petitioner is the wife of legally wedded wife of that TK Gopalan, who was serving as supervisor in the police radio Makuchung in the district of Makuchung, Nagaland. And her husband died living behind her and her daughter. It is also not disputed that the petitioner has received family pension for about 6 to 10 months following the death of her husband. However, it is only the problem is just because of the loss, because after the pension book was lost from her position. After arguing the matter for some time, the petitioner, the learned counsel petitioner, while producing the office memorandum dated, copy of the office memorandum dated 13/7/2015, Fred Ward allow her to approach the deputy commissioner of the concerned district as it provides that any inclusion or change of nominee, which shall also be include post-retirement spouse and children, for the purpose of family pension after the death of the pensioner in respect of the settled case, shall not be allowed without proper inquiry by the deputy commissioner of the district. The prayer of the learned counsel petitioner, the learned counsel for the state respondent as well as the respondent number 5, that is IA, Accountant General, have no objection to the prayer of the learned counsel for the petition. Next prayer. It is noticed that the respondent authorities, the state respondent as well as the respondent number 5, that is Accountant General, have filed their respective additional affidavit stating that the records have been weeded out as per the rules, and the respondent number 5 states that unless the required documents are submitted by the state government, the office of the Accountant General is handicapped to proceed with the matter. It is settled that the settled law that the pension is not a bounty. Therefore, the state, the respondent authorities are expected to decide the matter expeditiously, and such technicalities of office procedure should not be allowed to should not be allowed should not be allowed the petitioner to suffer for such pensionary benefits, family pension as well as pensionary benefits of her late husband T.K. Gopal Mr. In view of the above. No. On having considered the submissions and prayers made by the learned counsel for the parties, the petitioner is allowed to approach the concerned deputy commissioner for allowed the deputy commissioner concerned for appropriate actions in terms of the rules, as well as to redress the grievance of the petitioner expeditiously. With the above observation and direction, this writ petition is still disposal. You approach, but then in the event of your assistance, you'll assist, especially accountant general, and immediately.
If I may,
release.
have we got has this OM have been quoted?
Yes,
Because the commissioner is not the party, so this OM may be quoted in the order, Your Lordship.
no, before this, the learned counsel for the petitioner shall file appropriate application along with the copy of the annexing the copy of the office memorandum dated 13 July 2015.
Deeply appreciated.
Oh, yeah. Huh? Maybe this for the answer Ali. What to do?
My friend Pendawang is not present today.
Huh?
Who is supposed to be, he is the CBI counsel, Mr. Pendawang.
Lima Wapa.
Pendawang, he is from
Pendawang.
Singapore. Yes.
2016 matter. That's why we have been fixed it for. Okay, then in that case, next week. Next week.
My lawsuit, I fixed the date because.
Yes.
It's on number. That can be fixed, we can inform that. Okay, but it's 600.
Lima Wapang.
Pendawang.
Wapang.
Yes.
He asked for a time
No.
That's okay. But.
so that you can inform.
We will inform him, but the date can be fixed.
In fact, this matter has been listed for so many times before this court. Somewhere other. CBI will be required.
Maluda, I'm asking for the custodial date
But
of my brother.
yes, that I have seen. But then one more problem is that unless there's an inquiry, establish the date of a custodial death, and for that matter, any kind of violation, under the public law remedy, it may be little difficult to grant a compensation. But whether this would be practicable or not, if there is no inquiry as such, inquiry can be, I mean, can direct to cause an inquiry also. But this is something not happy state of affairs. The inquiry and all those things. The statement, affidavit and all that thing. It's not that happy state of affairs. You just casually they have made a, I think,
And
Just say that, you just cannot say that he just, according to the state, you are trying to project that he died because he had a problem, I mean,
Suicide.
ailments or suicide.
Your Lordship, we had a magistral inquest. We went
that's
for
what-
inquiry. Your Lordship, there was an
No,
inquiry.
that's what I've said, the statements. Have you read the
Yes,
statements?
absolutely. Yes, Your Lordship.
Casually, the statements are casually made.
Your Lordship, if this Lordship feels deems it that like there should be a commission, then Your Lordship, if this Lordship is not satisfied, then that Lordship to that extent cannot say anything, but as far as the compensation is concerned, Your Lordship, there's a medical
Compensation,
evidence.
There's little difficulties there. Anyway, when do you want?
Next Monday.
We'll make it a last chance. And you kindly inform whoever appears for this case. No further adjournment. Heard, Mr. I.N.T. Longsir, learned counsel for the petition, and also had M.S. Libika for respondent number,
For the state.
state respondent,
for respondent.
Younger Bati for respondent number.
One.
You are one. Then you just Younger Bati for learned CGC for respondent number one. And M.S. Libika for learning state council for state respondents. Non appears for respondent number
8. CPI.
8.
Yes.
8.
And Lok Ayokta vigilance, I've made the party respondent, which is now.
Vigilance, so you'll be appearing. It's the government, state government department,
Which one you?
vigilance.
Earlier.
Vigilance, you should appear.
No, your Lordship, they have their own standing council. It's an autonomous body, Your Lordship.
No, the earlier there was a standing council. In Muzui was happening. But is no more the standing council.
You find it out. Non appears for respondent number 7. Who is the
9.
9, 8, 9, and who is the Lokayukta?
Lokayukta is 9, Your Lordship.
Vigilance?
Yeah, vigilance, Your Lordship.
Lokayukta same. Non
Lokayukta.
appears for respondent number
Previously it was vigilance, now it is Lokayukta. Your Lordship.
Yes.
for respondent number 8 and 9. Non appears.
4 in 9. 4 in 9, my lord. 8 is the CPI.
4
Okay.
and 9, but more or less same, because vigilance comes under Lokayukta. Your Lordship.
Then non appears for respondent number 4 and 9.
4 and
My lord.
4, 8, and 9. On the prayer of learning council for the parties, list this matter on
Thursday, that is what my learned government advocate.
this Thursday.
next Thursday, Your Lordship.
Thursday is a holiday.
This Thursday is holiday, next Thursday.
Next Thursday. When is next Thursday? 5th, 10, 20,
My lord.
23. Notice in view of the this matter. According to prayers allowed, list this matter on 5/10/2023.
I'm sorry. I have some engagement on 5.
You decide that you decide, but we are giving it a last chance, no adjournment, further adjournment.
Friday.
But not on 5th.
Since this matter is of 2006, relates to custodial debt, no further adjournments have been granted on the next date.
The next. Tuesday.
6. No.
6 to Friday.
October.
6 is Friday, so usually, Your Lordship, whether it will be
10 is to stop.
10, Your Lordship.
10. 10/10/2023.
Much obliged.
I wanted to dispose of this matter.
I will say again. On 10 also I have engagement.
Then next week, Monday. Monday is what?
Monday, Your Lordship, I have some difficulty.
Okay, then third, make it third,
Third, Tuesday.
Tuesday. Tuesday also we have a problem.
I have a somewhere if it's a more. Second.
No, you take it, sixth, sixth, 10. Friday, it will not take much.
No problem.
March applies.
Right.
Uh,